praising the council about parks, which was also not on the agenda, was welcomed warmly. This is exactly the pattern alleged in Hannum versus Jackson Township. The federal court allowed this lawsuit to proceed because it recognized that even facially neutral rules, like stick to the agenda, become unconstitutional when applied selectively to silence critics. The rule wasn't the problem, the enforcement was the problem. Now, watch the correct response. The first resident returns to the microphone. He says, "Council President, I am returning to the microphone. I note for the record that you just allowed a speaker to comment on the parks program, which is not on tonight's agenda, while you ruled me out of order for discussing campaign contributions, which is also not on the agenda. Under the precedent established in Hannum versus Jackson Township, a federal case filed against this council, you cannot selectively enforce Section 312 to silence critics while allowing supporters to speak on any topic they choose. This is unconstitutional viewpoint discrimination. I am resuming my remarks about the Hyson Road land deal, and if I am removed, my attorney will be filing a supplemental complaint in the existing federal lawsuit by Monday morning." Dead silence. The council president's face goes pale. Knowledge is power. This resident didn't just know the law, he knew the specific lawsuit against his own council. He turned their own legal exposure against them. When officials know that a federal judge is already watching their conduct, they think twice before violating your rights again. If your municipality has been sued for First Amendment violations, use that lawsuit, reference it, remind them that the court is watching.
In Filipowski versus Stack, filed in federal court in 2024, a citizen journalist known as Leroy Truth was arrested at a Union City Board of Commissioners meeting. His alleged crime? Refusing to speak from a podium. But there is no New Jersey statute requiring a citizen to use a podium. This case exposes the conduct versus content trap, where officials manufacture a minor conduct violation to suppress the content of your speech. Watch this dramatization based on the actual incident. A Union City Board of Commissioners meeting. The room is tense. A journalist and activist enters and stands in the aisle, not at the podium. He holds papers. He says, "Mayor Stack, I have questions about the no-show jobs in the housing authority that I've been reporting on. Public records show..." Mayor Stack interrupts. "Sir, you need to come to the podium to speak." The activist responds, "I'm fine speaking from here. I can be heard clearly." Mayor Stack insists. "It's the rule. You speak from the podium or you don't speak at all." The activist challenges. "What rule? What ordinance number? Show me the statute." Mayor Stack turns to a police officer. "Officer, if he won't come to the podium, remove him." The officer approaches. "Sir, you need to come to the podium or leave." The activist asks, "Am I being detained? On what charge?" The officer responds, "Disorderly conduct." This is what happened to Leonard Filipowski, known as Leroy Truth, in Union City. He was arrested, handcuffed, charged with disorderly conduct. His crime? Not standing at a podium. But here's the legal reality. There is no New Jersey statute,
No ordinance in Union City's municipal code that requires a citizen to speak from a podium at a public meeting. The podium rule was invented on the spot as a pretext. The real reason for the arrest? Filipowski had been investigating Mayor Stack's administration and publishing his findings on YouTube. This is the conduct versus content trap. Officials manufacture a minor conduct violation to suppress the content of your speech. Now watch the correct response. The activist speaks calmly to the officer. Officer, before you act, I want this on the record for the kingdom. I am citing Filipowski versus Stack, a federal civil rights lawsuit filed against this very administration. There is no New Jersey statute and no Union City ordinance requiring a citizen to speak from a podium. My refusal to use the podium is not disorderly conduct and does not constitute substantial injury under state law.
The Supreme Court's 2024 ruling in Lintka v. Freed established that a public official's social media page is a public forum subject to the First Amendment if they have actual authority to speak on behalf of the state and exercise that authority in their posts. Blocking critics on official social media is unconstitutional viewpoint discrimination. Watch this scenario unfold in the digital space. A mayor's Facebook page. He posts regularly about town meetings, new ordinances, and constituent services. A citizen sees a post claiming the budget is balanced. She types a comment. Mayor, your claim that the budget is balanced is misleading. You moved $2 million in debt off book to the utility authority. The public deserves honest numbers. The comment posts. 3 seconds later, the screen flashes. You have been blocked by this user. The citizen says, he blocked me. The mayor blocked me for pointing out that his budget numbers don't add up. Before 2024, officials could hide behind the argument that their social media was personal, but the Supreme Court closed that loophole in Lintka v. Freed. The court established a clear two-part test. If a public official has actual authority to speak on behalf of the government, and they exercise that authority in their posts, announcing meetings, discussing policy, responding to constituents, then that page is a public forum. And in a public forum, blocking someone for their viewpoint is unconstitutional, period. Now watch the correct response. The citizen sits at her computer and drafts a formal letter. She reads it aloud as she types. Dear Mayor Thompson, your official Facebook page functions as a public forum under the Supreme Court's ruling in Lintka v. Freed, 601 U.S. 187, decided in 2024. Your page meets both prongs of the court's test. You possess actual authority to speak on behalf of the municipality, and you exercise that authority by posting official announcements, policy updates, and constituent communications. By blocking you for posting a critical comment regarding your budget claims, you have engaged in unconstitutional viewpoint discrimination in a designated public forum. I demand that you unblock me within 72 hours. If you fail to do so, I will file a formal complaint with the ACLU of New Jersey and pursue legal action under 42 U.S.C. Section 1983 for violation of my First Amendment rights. This letter is being copied to the municipal clerk for inclusion in the public record. Notice the structure. Identify the legal statement, apply it to the facts, make a specific demand with a deadline, and state the consequences. This isn't a rant, it's a legal notice. And it works because it demonstrates that you understand the law better than the official who violated it. Most officials will unblock you rather than face a federal lawsuit they know they'll lose. You've just seen 6 real legal principles enacted, showing both how officials violate your rights and exactly how to respond. Let's recap your toolkit. Number 1, disagreement is not disruption. Cite State v. Kane and State v. Brennan. Number 2, rude speech is protected speech. Cite State v. Charzewski.
Number 3, if they allow praise, they must allow criticism. Cite Bessler v. Board of Education. Number 4, selective enforcement of rules is unconstitutional. Cite Hannum v. Jackson Township. Number 5, there is no podium requirement. Officials cannot use conduct pretexts to suppress content. Cite Filipowski v. Stack. Number 6, blocking you on official social media is unconstitutional. Cite Linke v. Freed. These are not abstract legal theories. These are weapons of accountability, tested in court, proven in practice. Print them, memorize them, bring them to every meeting, share them with every activist you know. Because when citizens know the law better than the officials who are supposed to follow it, democracy wins. This has been an Oath Investigative Report. Stay informed, stay vocal, stay free.